It's not a respecter of persons. Deal with the situation as they are presented to you. You don't have any personal interest in whatever is placed before you. If you know that you have any personal interest, the moment you realize that, then try to resile. Otherwise, there will be a lot of challenges. I wish you all the best. I wish you God's guidance. If there's any problem, we are not saying that we are beyond the problems ourselves. We can fall into problems. But let us put our heads together. So if there's anything which is beyond your own comprehension, beyond your own capability, please let us put our heads together so that we salvage at the tail end of it the situation.
Just before we delve into the next issue, we want to just quickly inform that we did invite the Minister of State for Power, but unfortunately, he was not able to make it today. Hopefully, this would be a reason to come on Sunrise Daily. But right now, let's talk about the judiciary, where we have a series, beginning today, to look at different sectors of our polity and try to preview into the year 2020, what's likely to happen, what are the issues that we're leaving 2019 with, and what are the issues that could determine the progress or not of the future, that's the year 2020. To begin this series with us, we have a legal practitioner in the person of Mr. Jiti Ogunye. Thank you very much for joining us.
It's my pleasure. Thanks for inviting me.
Yeah. 2020 is just a few days away. What do you see for the judiciary? First of all, what are the issues, contending issues, outstanding issues in the judiciary, and which would go into 2020 with us and may determine what 2020 will be like in the judiciary?
Well, thank you for inviting me. 2019, has been a very turbulent year for the Nigerian judiciary. And the facts are there for all of us to remember. You know that it was the year that we had, as it were, the head of the judiciary, and I'm talking about the former CJN, being removed from office in a very controversial manner. Up to now, there has not been a consensus in the legal community, and I'm talking about legal profession community, and in the larger political space on whether the manner in which his removal was effected was appropriate. And so, in the year, literally, the judiciary has been in the eye of the storm. And on many occasions, our people, and many of them non-lawyers and non-judicial officers, have taken a serious swap at the judiciary, even when, on many occasions, not too many people understand the nitty-gritty or the whole issue. Now, the judiciary is an important arm of government. It occupies a special place in our democracy and in our constitution. Is the third arm of government and is so symbolically placed in the constitution. You have section 4 providing for the legislature, the first arm, section 5 providing for the executive, and section 6 providing for the judiciary. The judicial arm of government is the only arm of government that has the power to, as it were, not only interpret our laws, including our ground norm, the Constitution, but also use its power of judicial review to look at what the two other arms of government are doing. Not legislative oversight, the legislature has that, over the executive arm of government, but it is the third arm of government that looks at what the two arms of government are doing. And so it's possible for the judiciary to take a law, a piece of legislation, and then examine it, and then use its blue pencil rule to delete some aspects that it feels are not in consonance with the provision of the Constitution or things like that. And also use the power of judicial review to look at executive and administrative actions.
Has the judiciary been doing that?
The judiciary has been doing that. The judiciary has been doing that.
Some would wonder, I mean, maybe educate us. How does the judiciary do that? Because many people would say, look, all the judiciary does is just interpret. And whenever there is any need for a review, it goes to the legislature.
No. The power of judicial review is different from the power of amendment of an extant law by the legislature. The power of judicial review is there to ensure that the executive branch of government and the administration, and I'm talking about administrative law now, conform with the law in its operations. And if any act of the executive is ultra vires the Constitution or contrary to an enabling law or unreasonable, the judiciary indeed can step in to nullify such an act. And for the law, as I've said earlier, the judiciary can take a piece of legislation and look through it and then delete some sections that it feels are not in consonance with the provision of the Constitution. And the judiciary has been doing this. I'll give you an example. In the life of the 7th Assembly, when the Electoral Act was to be amended, recall that there was a lot of controversy about whether the legislature could insert in the proposed amendment the timetable for elections, the order of elections. And some lawyers and some persons said that no, they were impinging on the powers and the discretion of the Electoral Commission, INEC. I didn't share that view because the order in which the election was to be conducted is listed in the Electoral Act, meaning that it was the legislature that gave that order, that sequence. So if it was the legislature that gave that order or sequence, it stands to reason that the legislature could also amend it. Anyway, some persons, senior lawyers, went to the Federal High Court to say, hey, legislature, stop. You cannot even legislate. Of course, that was not right. But the Federal High Court injuncted the National Assembly. And the case went to the Court of Appeal thereafter. When it went to the Court of Appeal, it was no longer, technically speaking, a live issue because the issue of the amendment had been rested and we are facing an election. And some of the senior lawyers who took the matter to court, implored the Court of Appeal not to deliver its judgment. That it's already, and they said, no, we'll deliver the judgment. And a very important judgment was delivered to the fact that you cannot prevent a legislature from legislating. What you can do is that if the legislation comes out as a product, you can go to court and then ask the court to review that law and then to make a pronouncement on it. If the aspect of the law that are not in consonance with the provisions and dictates of the Constitution, of course, this will be deleted. Now, so the judiciary has been doing that.
Right. I'd like to take you back. When you referred to the removal, one of the major happenings in the judiciary this year, the removal of the former CJ, and you mentioned that till now, members of, people in the judiciary are still finding it hard to reach a consensus as to what should have happened, whether it was right or not. And it brings to mind a big question about division. Because people say that, the judiciary should not be where it is now. And I want to ask you, do you think there are divisions in the judiciary such that it's hard to, come together and chart a way forward?
Well, I don't think so. I don't think that there's division in the judiciary right now. There was no consensus on that issue. But that is not tantamount to saying now that the judiciary is divided. During the Castina Alu, Justice Issa Yosalami in Broglio, of course there was a deep division in the judiciary. There was a division. And we ought not to have had that division if the rule of law was followed. Because you had a president of the Court of Appeal doing the right thing, resisting forces that wanted to manipulate and ensure a favorable outcome in respect of an election. Petition. It was told illegally and unconstitutionally to disband a panel that he had constituted by the CJN. And he said he wasn't going to do that. It was following all that you then had a situation where an amendment of the Constitution was inspired, and the Supreme Court has now started taking governorship election petition. It used to be a two-stage process. And we've seen the effect of that on the health of the Supreme Court. Because, you see, politicians will do whatever they can, not only to win election, but to win election petition.
So you think
so in that way, the judiciary is exposed to all the subtle and not so subtle attempts to manipulate, trial outcomes and all that. Okay. So I'm saying that now we don't have that kind of division that you're talking about.
Okay. We'll take this a little further when we come back from the break, looking at the judiciary in 2020. Please stay with us. Mr. Jiti Ogunye is still with us, and we're forecasting, so to speak, previewing the judiciary in 2020. Well, so many have said in this year and over the years, the wheel of justice seems to grind too slowly. And a number of people have been calling, including you perhaps, for judicial reforms. What's your take, and what should we be reforming?
Now, our judiciary is confronted with a number of challenges. Ethical challenge is one of them. Administrative gridlock is one of them. And structural problem is one of those challenges, and I will go over them. Let me take the last, because you asked a poignant question. The wheel of justice grinding so slowly, but lawyer will say, surely. Let me take the last one, structure. What is the structure of Nigerian judiciary? Because in a large measure, the structure of the Nigerian judiciary contributes to the gridlock you're talking about, the slow pace of administration of justice. This structure is a unitary structure in a supposed federation. So what people that have looked at the judiciary very well are calling for is the refederalization of the Nigerian judiciary to ease litigation and adjudication. This structure is like a cone, it's like a pyramid. It has a very broad base and a tiny summit, a very tiny zenith. So we have so many high courts in Nigeria, up to 1,000, if not more, of courts. Federal, state, national industrial courts, up to 1,000 or more judges exercising judicial powers that are appealable. So cases snake from there through the labyrinth of judiciary, through the Court of Appeal to the Supreme Court, that the Constitution says can have up to 21 justices. Since 1999, it has never had the full complement of 21. And with those justices, usually we have 2 panels at the Supreme Court. A panel of 7 if it's a constitutional matter, or a panel of 5, right? Maybe at best we can have 3 panels. This small court, but of immense powers, then takes all the appeals, both criminal and civil appeals, and constitutional matters that get to the court as a court of first and final arbiter. So, why are you not going to have a bloated docket? Why are you not going to have, at the Supreme Court, cases being slated for 2 years before they are heard? Dates, 2021 dates are being given currently, and so on and so forth. So why will you have that problem? So the structure does not accord with the speed that our people desire.
So what should we do?
You have to refederalize the Nigerian judiciary.
What do you mean?
And the law and the outcome of education will be no less certain, because we have precedent, we have stare decisis that we follow. What I mean is that in every federation, there is a devolution of authorities. There are federal powers, there are state powers. Now, unlike in the United States, where every state has its high courts, its court of appeal, and its Supreme Court that take ordinary cases, not federal cases, where you also have federal judiciary. Here, we have state high courts feeding a federal court of appeal and a federal Supreme Court. There's a problem with that. Okay. So you will need to refederalize it, so that even if you can say that we don't want to atomize appellate jurisdictions in this country, so every state shouldn't have a court of appeal and a Supreme Court in Nigeria, we can have regional high courts, regional court of appeal, and regional Supreme Court. Okay. To create cases like murder, criminal cases, things like that.
Okay.
Right now, all sorts of cases, including traffic offenses, possibly, can pass through
all the way to the Supreme
from the magistrate court all the way to the Supreme Court. Okay. So we have a problem with that. Okay, and we need to deal with that on the issue of structure.
This is definitely something that you in the judiciary have talked about, and it's something that we will also keep our eyes on. I have to thank you very much for being a part of our conversation this morning.
Thanks so much.
Jiti Ogunye is a legal practitioner. We're back in a moment to take on another issue. Just before we go, stay with us.